be lodged in a murder case after inquest has been held. Paragraph 18. The first information report has been lodged on the basis of the statement made by PW11 to the information himself at the spot. If the said prosecution witness who claimed himself to be the eyewitness was the person who could lodge a first information report, there was absolutely no reason as to why he himself did not become the first informant. The first information report was recorded on the basis of his information given by the first information at the spot. All information given by him to 13 was made before the investigating officer himself. What prevented him from doing the first information report is beyond our comprehension. PW11, we may place on record, categorically stated that he had disclosed the detail of information to all concerned. Therefore, it is expected that the first information was informed thereabout. We have noticed hereabout that the information given by 13 had at least been recorded by the police in the crime register, and he categorically stated a few facts which the main accused communicated murder his brother Shivrajji Patil and such. Even the place where the murder took place was known to him. If we are to believe the investigating officer, he recorded the statement after holding inquest. The detailed report is in regard to the nature of injuries as also the place where the prepared. Such an attempt on the part of the investigating officer has been deprecated by this court in a larger number of decisions. All other witnesses, including the Punch witnesses, must have been present there. If despite the same, according to Punch witnesses, at least in respect of such and such unknown person are said to be his assailant, it is evident that PW1 did not disclose the name of the assailant, at least all of them before 9, as also the investigating officers. In a case of this nature, enmity between two groups is accepted. In a situation of this nature, whether the first information report was anti-time or not also requires serious consideration. First information report in a case of this nature provides for a valuable piece of evidence, although it may not be substantial evidence. The reason for insisting on lodging of first information report without undue delay is to obtain the earlier information in regard to the circumstance in which the crime had been committed, the name of the accused, the parts played by them, the weapon which has been used, also the name of the eyewitness where the parties are at loggerhead and there had been instance which resulted in death of one or other. Lodging of first information report is always considered to be vital. The Code of Criminal Procedure provides for certain internal and external checks, one of them being the receipt of a copy of the first information report by magistrate concerned. It is not in dispute that a grave case of this nature, the copy of first information report was received by the magistrate 4 days later. No explanation has been offered. Therefore, 157 of the court's mandates that the first information report should be sent to the magistrate within a period of 24 hours. It has not been disputed that the occurrence took place near the district headquarters. There cannot be any reason whatsoever as to why the first information report was sent after 4 days.
Mr. Udin, just a moment.
উষ্ণতা রিকোয়েস্ট টাইম দেখানো, রিকোয়েস্ট টাইম দেখানো, টাইম 10:46. Here, my lord, for a moment, your lordship, kindly go to the paper. It is not a case of the prosecution that the assailant is unknown to us. Everybody subsequently named him. In the GD entry, the person who first won Abul Hussain, he made the telephonic report message. On the basis of telephonic information, GD entry was made, page 204. Nobody has been named. Here I have already placed before your lordship the reliance.
Get your point. Get your point.
And FIR was that the FIR which is treated as FIR and the basis of which the case was registered as police case, that was registered laws after dead body was taken to hospital. It was like 8 p.m. My next citation is, my lord, 2019 9 SCC 738. Here I am relying, my lord, on 20.4 paragraph. This is relating to, my lord, non-examination of vital witness.
It was in 1999 SCC.
19 9 SCC 738. I am relying on paragraph 20.4.
99 SCC 738.
Paragraph 20.4. It is not the case of the prosecution that SI was prevented by any reason to immediately attend to his duty after reaching the site. It is also not the case that he attempted to make any inquiry from any person until arrival of the complainant and other family member of the deceased. Even if it be assumed that the other family member of the deceased were on the way and the ASI knew about this fact, nothing had prevented him from attending his own duty of investigation. Strangely enough, even the first Panchinama was prepared only after reaching of the complainant. It is also not clear as to why the statement of the children of the deceased were not taken with his daughter. 16 years of age was very much present at the site. It is also not explained as to why in this kind of matter carrying suspicious overturn, PW9 did not make any inquiry from any of the neighbors who were available at the site and from the tenant who was residing at the ground floor of the same building and whose washroom was allegedly being used by the deceased. It is difficult as to say that the conduct of investigating officer has been totally free from doubt. Apart from the above omission, at the very initial stage, we find absolutely no reason that the investigating officer, even after allegedly making inquiries in the locality regarding the character of the appellant from 5 to 10%, neither mentioned this fact in the investigation report nor recorded the statements of any one of them. This investigation officer further stated to have joined the children of the appellant in the investigation, but did not record their statement either. This officer also did not bother to take the statement of the tenant, whose testimony would have been the immense significance, looking to the nature of the accusation, as also the factors revealed the building in question. 21. In this case, it is also interesting to notice that though the prosecution had cited the other relation of the deceased as witness, including his mother and brother-in-law, but did not examine them before the court, withholding of relevant witness would only lead to further adverse inference that, if examined, they would not have supported the prosecution case. This is apart from the fact that the investigating agency avoided to include any independent witness in the investigation and did not carry out necessary inquiries from the person other than in-laws of the appellant. Herein above, we have only indicated a few broad aspects of the.
Mr. Then this, I don't know whether it will help you. Here, in this case, the facts are he was convicted on the basis of circumstantial evidence.
Yes.
And therefore, the court says that you have to draw a complete picture. Because it was suspicious circumstances.
Circumstantial evidence before going, I am submitting. During my submission, I have said as many as 4 white witnesses. The first comer to the incident, the spot, the minor sisters of the deceased. According to PW 6 and 7, they reported that she was vomiting, vomiting blood. That means she was not died instantly. They would have been the most vital witness in this case, my lord.
Okay.
So relying upon circumstances would not have been arise at all, my lord, had they been examined.
Okay. Right.
Then, my lord, the PW1 says, while he was working, he showed me while I am proceeding towards the roof, from the top of the roof. Along with someone, another person was there, some Madhu Chandra was there. He was not examined. The mother of the victim was not examined. The person who informed the police immediately after the incident was not examined. So this is my case now.
Right, right. You're raising a suspicion.
That the last paragraph I have read, my lord, categorically it is said. The prosecution was, my lord, unfair that had they been examined, if they are examined, the two sisters and mother, it will go against them, my lord, because as my humble submission on that point is that as the case is projected against me, it is not as such.
Okay.
Same on the same line, my lord. I will not read this paragraph. Just I am delaying, my lord. 2005, 13 SCC 624. Non-examination of vital witness. Here, paragraph 18. I am relying upon. 2005, 13 SCC 624. So I do, sir. The High Court, in our opinion, further committed an error in not drawing an adverse inference for non-examination of Sri such and such and such and such. It was for the prosecution to prove its case, even if the first information report, their name were not disclosed, but if during investigation materials came to the notice of the investigating officer that apart from Mongol Singh, two other witnesses had also witnessed the occurrence, he was duty bound to show the place where from they had witnessed the occurrence. In the site plan prepared by him and also recorded their statement under section 161 CRPC, we do not see any reason as to why adverse inference should not have been drawn for non-filling of the said statement before the court along with the charge sheet. Two 2009 9 SCC 221. This is for the purpose, my lord, the magistrate recording statement under 164. He is not examined, but the statement of 164 is relied upon. Paragraph 36. Kunal, however, would contend that the aforementioned documents, Exhibit 4, 5, and 6, were exhibited without any demur whatsoever. The respondent, furthermore, did not make any prayer to cross-examine the said witness. It is true that ordinarily, if a party to an action does not object to a document being taken on record, and the same is marked as an exhibit, he is estopped and precluded from questioning the admissibility thereof at a later stage. It is, however, tried that a document become inadmissible in evidence unless the author thereof is examined. The contents thereof cannot be held to have been proved unless he is examined and subjected to cross-examination in a court of law. The document which is otherwise inadmissible cannot be taken in evidence only because no objection to the admissibility thereof was taken. In a criminal case, subject of course to the shifting of burden depends upon the status and decision of the superior court. The right of an accused is protected in terms of Article 21 of the Constitution of India. The procedure laid in that behalf thereof must strictly comply with exhibit such and such, in our opinion, are not admissible in evidence in the criminal trial. So, my submission is that the FIR, first submission on buttressing upon this citation. The first submission is that the FIR was written by somebody else on the basis of which the police case was registered. The author of the FIR not examined. Next, the magistrate who recorded the 164 statement, he was also not examined. Buttressing my argument on these 2 points, I am relying upon this. Now, this is 1966, AIR 1966-119. Paragraph 9, confessional statement. Section 25 of the Evidence Act is one of the provision of law dealing with confessions made by an accused. The law relating to confession is to be found generally in section 24 to 30 of Evidence Act and section 162 to 164 of the Code of Criminal Procedure. Section 17 to 31 of the Evidence Act are to be found under the heading admission. Confession is a species of admission and is dealt with section 24 to 30. A confession or an admission is in evidence against the maker of it unless its admissibility is excluded by some provision of law. Section 24 excludes confusion caused by certain inducement, threat, and promise. Section 25 provides no confession made to a police officer shall be provided as against a person accused of an offense. The term of section 25 are imperative. A confession made to a police officer under any circumstances is not admissible in evidence against the accused. It covers a confession made when he was free and not in police custody, as also a confession made before any investigation has begun. The expression accused of any offense covers a person accused of an offense at the trial, whether or not he was accused of the offense when he made the confession. Section 27(6) prohibits proof against any person of a confession made by him in the custody of a police officer, unless it is made in immediate presence of a magistrate. The partial ban imposed by section 26 relates to a confession made to a person other than a police officer. Section 26 does not qualify the absolute ban imposed by section 25 on a confession made to a police officer. Section 27 is the form of proviso and partially leave the ban imposed by section 24, 25, 26. It provides that, this is important, when any fact is deposed to as discovered in consequence of information received from a person accused of an offense in the custody of the police officer, so much of such information, whether it amount to a confession or not, as relates distinctly to the fact thereby discovered. Paragraph 9. May be proved. Section 162 of the Code of Criminal Procedure forbids the use of any statement made by any person to a police officer in course of an investigation for any purpose at the inquiry or trial. So this paragraph, my lord, confession if made, it must be distinctly related. The leading to discovery incident, yes, already I have, my lord, submitted on this point. The first thing was that it was accessible to all. So it is not distinctly related because he was 2-3 days. Before leading to discovery, he was already in custody for 3 days. During this period, if a key of the house, which is stated to be under lock and key, is in the hand of someone, my submission was on that point that it, meaning thereby that it was accessible to all. It becomes open to all. So distinct relation the expression distinct relation under 27th Evidence Act is missing. On that point, my lord, I have not mentioned here, my lord, our High Court, a full bench decision. It was referred to by a division bench to the full bench. This decision, my lord,
Rajiv,
is very short judgment.
Rajiv.
Bircha Kurmi,
Oh, Birsha.
Birsa Kurmi versus State of Assam. 2009 3 GLT 117. I have not given here, my lord. Here, the full bench has also said the
What is this, sir? Is it 2009?
2009 3 GLT 117. Paragraph 5.
Name of the parties?
Bircha Kurmi, BIRCHA, Bircha Kurmi versus State of Assam. It was referred to full bench by division bench, and finding of the division bench is there. We are of the opinion that question is no.
Full bench আনা নাই।
Hmm?
Full bench ও judgment আনা নাই।
Full bench.
ওইটা full।
Full bench. Bircha Kurmi, 2009 3 GMT. I said.
জামা কোন?
We are of the opinion that the question is no more res integra and squarely covered by a decision of Supreme Court in AIR 1962, Supreme Court 276, State Punjab versus Barkat Ram. At paragraph 9, the Supreme Court held as follows. The police officer referred to section 25 of Evidence Act need not be the officer investigated into that particular offense of which a person is subsequently accused. A confession made to him need not have been made when he was actually discharging any police duty. Confession made to a member of the police of whatever rank and at whatever time is inadmissible in evidence in view of section 20. In the result, the question referred is answered that a confession made even to a police constable is inadmissible in law and the same is prohibited from being received as evidence under 25.
What are the paragraphs you are relying on?
Paragraph 5. Supreme Court decision is referred.
And
In paragraph 5, two paragraph of the Supreme Court judgment. Here the question was referred to full bench was that whether an confession made before a police constable is admissible. So referring the judgment of Supreme Court, it is held that in any rank, police officer and any rank, it is not admissible. Again, on leading to discovery point, my next citation is, my lord, AIR 1961, Supreme Court 1808. I am relying on paragraph 13 of the judgment. During the investigation of a
just a moment.
Thirteen also on the same line. Here one thing say the self-incriminating information has been given by the accused person without threat. In the there is a constant my suggestion to the that I was assaulted by police. I was under threat, and police made me to. So on that
But
point,
that suggestion is not there when the I was examined. That suggestion is not there when the I was examined.
IO suggestion not there. IO suggestion doesn't. But the other that suggestion is given.
Yes, sir.
IO suggestion doesn't happen. IO this suggestion are not.
Because in my notes, I have not mentioned about that.
Next, also leading to discovery, that is 1979 4 SCC 346. Very small paragraph. I am relying on paragraph 4. In this circumstance, therefore,
Just a moment.
Paragraph 4 of the judgment, last paragraph. In these circumstances, therefore, we are not in a position to rely on the judicial confession. As regards the production of the Tangia by the accused before the police, the High Court seems to have relied on it as admissible under Section 8 of the Evidence Act. As there is nothing to show that the appellant had made a statement under Section 27 of the Evidence Act relating to recovery of this weapon, hence the factum of recovery thereof cannot be admissible under 27 Evidence Act. Moreover, this is important. I am relying on this, that the accused had done was merely to take out the axe from beneath his coat. There is nothing to show that the accused had concealed it at a place which was known to him alone. Earlier, I have already submitted on this point. Known to him alone, and no one else other than the accused had knowledge of it. Am I clear, Madam? This is my. So, in this circumstance, the mere production of Tangia would not be sufficient to convict the appellant. In this case, I have already submitted, Madam, because it is the case of the prosecution where it is the evidence of the prosecution that the key of the house was with someone else of his family. It is not that the accused alone had the knowledge. And as regards thou, my lord, I have already in my submission, during my course of submission, I have said the thou is not, we cannot be considered a weapon because of the socioeconomic condition of this locality. Because thou, it is used as a instrument for cultivation work. May I proceed, my lord?
Yes.
My next citation is, my lord, 1987 3 SCC 480. Kancha Behera, Bastard State of Odisha. Paragraph 4, my lord, I am reading. 12. As regards the recovery of shirt or a dhuti with blood stain, which according to the serologist report were stained with human blood, but there is no evidence in the report of the serologist about the group of the blood, and therefore it could not positively be connected with the disease. In the evidence of the investigating officer or in the report, it is not clearly mentioned as to what were the dimensions of the stain of blood. Few small blood stain on the cloth of a person may even be of his own blood, specifically if it is a villager putting on this cloth and living in village. The evidence about the blood group is only conclusive to connect the blood stain with the disease. That evidence is absent, and in this view of the matter, in our opinion, even this is not a circumstance on the basis of which any inference could be drawn. I have already placed my submission matter that as already it is the expert evidence that blood, there was a blood in the dog. It is positive. FSL says it is positive of human, but grouping is not there. Had the grouping been done, the deceased blood group, there is no evidence that what was the blood group of the deceased, what was the blood group of the accused. This particular thing is quite absent in the whole process. So in absence of this particular thing, my lord, matching of blood group, this circumstance, the chain of circumstance, my lord, failed. There is a gap. So it cannot be come to the conclusion. The inference could not be drawn up against, ought not to have been drawn up. Next, my lord, 2014 4 SCC, page 16. and 20, I am relying upon paragraph 18. Apart from the omission on the part of PW 16 and 17, it is not mentioning to the police when they gave their statement immediately after the incident. The High Court has also analyzed their statement along with deposition of PW 12 and found them to be inconsistent and self-contradictory in the following manner. From the deposition of these three witnesses, the prosecution has tried to establish the circumstance of the accused having been seen in the company of the deceased last, but scrutiny of this evidence leads us to negative this aspect. According to 12, Soros, she was playing with victim and Parul, the deceased, arrived around 3 o'clock and shouted, Ladiu, meaning young girl. Therefore, the Parul ran away and the victim was left behind. She had the accused sent the victim to purchase a Bimal. She also says that thereafter she went home and was doing lesson. She was the victim going to the packet of Bimal to give it to the accused. Therefore, necessarily, if her say is taken at face value, then also the victim was seen going to the house of the accused with a packet of Bimal, and if she did factually reach there at that point of time, neither Soros nor Parul was present. Conclusion. 20, paragraph 20. Even the medical evidence on which strong reliance was placed by the learned counsel for the state, it is no help to arrive at the conclusion that the guilt of the respondent stand proved beyond reasonable doubt. When the respondent was arrested on 19/8, Panchnama was drawn. In that it is recorded that the accused had abrasion on chest, back, and shoulder caused by nail, and also that there was swelling on his penis and swelling on skin with abrasion. Immediately after his arrest, the respondent was sent for medical checkup. As per the medical report, there were injuries on chest and back, which is described by the doctor as liner absorption. There were no foreign particles in his nail. The doctor also admitted in his cross-examination that he did not notice any injury on the penis of the accused. Therefore, this shows the contradiction between recording of medical condition of Panchanama and the medical examination conducted by the doctor, insofar as they relate to the injury on the penis of the respondent. The High Court has rightly observed that the Panchnama has recorded aberration and therefore it could not have disappeared within such a short time. It is reflected adversely that on the prosecution case as regard injury found on the. However, the postmortem does not indicate presence of any trace of skin of the accused in the nail of the deceased. Further comments of the High Court in the impugn judgment about the medical evidence. This is, my lord, I am relying upon only point of 376 and POCSO. So this part, my lord, I have said, my lord, the necessary ingredients for proof of an offense under 376 and POCSO 4 are totally absent. Absolutely, there is no evidence. Next, my lord,
Just a moment.
evidence. Evidence. Section 26. Last of it. Otherwise, doctor's evidence is clear. Madam. Doctor says there, the prosecution case is there was the injury on the breast, but doctor's evidence is clear that there was no injury. The next citation is 2017 5GLT.
Huh.
2017 5GLT, this is full bench judgment 144. 44. Here the question was, my lord, before full bench that the expression magistrate under section 26 of the Evidence Act. In this case, executive magistrate was present altogether during the course of leading to discovery incident. Whether it is executive magistrate or judicial magistrate. The findings, my lord, 36.
That is in respect of section 26, sir. That is in respect of section 26.
26.
I'm not leading to discovery 27.
Expression, confession and statement.
Again,
Also. Oh, yes, you are really So, full bench, it is held that magistrate, it must be, my lord, Judicial magistrate.
Pardon me.
Leading to discover the confessional statement. The case is there. Magistrate was there in front of magistrate while leading to this 26, 27, the same line. The executive magistrate was present. Before executive magistrate, he has disclosed the fact. The executive magistrate here, full bench says magistrate 26, the expression magistrate, it is judicial magistrate, not executive magistrate. Paragraph 36, this is the finding. Last, this is the finding. We answered that the reference by holding that the expression magistrate appearing in section 22 of Evidence Act would mean only a judicial magistrate and not an executive magistrate. My next case, may I proceed? Ma'am? তো যদি আসে ফাইসন সাইটেশন ফাইসলাইন ফাইসলাইন Munni Krishna versus Elias Krishna, etc. We looked at this one. By names are shown. By names are shown. By names are shown. By names are shown. My next, my lord, 2018 1 GLT 726. 726. One year. One. 726. 31 to 33 paragraph. Siddharth. Siddharth. This, my lord, case law, I am relying upon on the point. The 2018 1 GLT. Basically improvement. My lord. The PW1 in his FIR, the lordship already has gone through, my lord. The FIR and his deposition, totally separate story has projected. In FIR, he has stated in one way, in the deposition, he has improved his person. Moreover, all the prosecution witness already the from the cross-examination of IO, I able to establish this contradiction. 161 they have stated in one way, subsequently before court they have stated in another way. So on the basis of improvement, this citation is, my lord, paragraph 31. From the cross-examination of PW 13, it is clear that evidence of PW 1, 2, 3, 7, and 18, here 13 is IO. Improvement over what they stated before police under 161 CRPC, that too on material aspect. In their statement under 161 CRPC, the narrative presented by the prosecution witness was that the deceased and subsequently the father were assaulted by Steve. Before the court, this was grossly exaggerated to include assault by dove, spade, spear, etc. It was also stated in court that veins of the victim's hand and legs were cut by dove. This exaggerated version is not supported by medical evidence, which categorically ruled out assault by sharp and pointed weapon. The injury were sustained by blunt object, and the death was caused due to coma resulting from injuries sustained in the head. In fact, PW10, the doctor categorically stated that the deceased sustained injuries only by blunt object, and there was no cut injury by sharp weapon further. So I am relying, my lord, the improvement they have made. So my submission is that, relying upon this citation, my lord, the prosecution witness improved their version stage to stage. The more particularly PW1 in his FIR, he has projected the story in one way. Subsequently, he has improved his version on the other. Already your lordship has done both the FIR and his evidence. So to buttress my argument, I am relying upon this on this part. मेरे से 161 is to higher zero percent. My last citation, my lord, this is a latest Supreme Court judgment on the point of circumstantial evidence. I could not collect, my lord, the citation, my lord, mode of citation. This is a judgment rendered in criminal appeal number 1597 to 1600 of 2022. The date of judgment is 30/9/2022. In this case, my lord, 9, 11, 12, and 13, I am relying upon this three paragraphs. So here, my lord,
What is the date of judgment?
30th September, 30/9/2022.
Party now.
This earlier, this is the latest judgment. Already on that point, I placed my citation, my lord. In a case of circumstantial evidence, the court has to scrutinize each and every circumstance possibility, which is placed before it in the form of an evidence, and the evidence must point towards only one conclusion, which is the guilt of the accused. In other words, a very heavy duty is cast upon the prosecution to prove its case beyond reasonable doubt. As early as 1952, this court, in its seminal judgment, Hanuman Gobind Nargunkar versus State of Madhya Pradesh, laid down the parameters under which the circumstantial evidence is to be evaluated. It states. So these are the. Here, my lord, your lordship kindly consider one thing, my lord. Paragraph 13 says, exclusively it must be proved. There cannot be any room of doubt. And if there is a true view even, then that point I have already submitted. I am entitled to benefit of that. So these all about my lord case laws, my lord.
Party number of my last case.
Eh?
Last case of party's name.
Party to whole Muni Krishna, Elias Krishna, etc. versus state by Ulsur PS. So, my lord, after placing my all this citation before your lordship, I am summing up my submission, my lord, in this way. My first case is that there is absolutely no evidence and for conviction under section 4 and 376 of the IPC, 4 of the POCSO and 4. So there is no rape. There is not a single evidence, neither medical evidence nor nobody has. So this is, my lord, basis of the whatever has been placed before record, my lord. My humble submission is that, my lord, the accused is entitled to, my lord, acquittal under his conviction. Now, next part is, my lord, circumstantial evidence 302. 302, my lord, I have already placed reliance and I have, my lord, pointed out so many, my lord. There is, my lord, huge gap in the chain. Prosecution failed to prove that the dhow which was seized from the house of the accused was in fact used in commission of offense. That the dhow contains the blood is matched with the blood of the deceased or the accused. That part is also missing. Therefore, on the basis there is a, my lord, improvement is there. I have already said there the confessional statement as regard I have already, my lord, submitted, my lord. So I am entitled to benefit of doubt, and my humble submission is, my lord, the accused is entitled to, my lord, acquittal from the charge level against him. And my additional submission, my lord, apart from this, I will take only 2 minutes on that. My additional, in any case, as I have said, my lord, that the circumstance, there is no evidence under 376(4). That is there. But in any case, my lord, if your lordship is of the opinion that the circumstance chain is complete, then, my lord, my humble submission would be, my lord, your lordship for a moment take the postmortem report. Postmortem report to page 197. And finding is page 202. Lordship, 202. In my opinion, the death was due to irreversible hemorrhage, shock, and is caused by sharp and hard weapon. This part remains unassailed. On that point, we have not made any cross-examination. So my additional submission on that point, the death of the deceased, if your lordship, in case, therefore this is my additional submission, was not directly due to injury sustained by her. It is not due to injury sustained, it is due to hemorrhage from the injury sustained. So it will not come under 302. It will, the impulse will reduce. My lord is well over. So on that point, my humble submission is that it is not a case of 302. In the case your lordship is found that the circumstance prosecution is able to establish this circumstance, then my submission is, this is my additional submission. I am highly obliged, my lord. Your lordship has given me enough opportunity to place my case, madam. I am obliged.
May it please the lordship. Now we will stick to only the criminal appeal. We will not go into the death sentence. In order to stick to this criminal appeal only, I would like to place those circumstances because the case rests on the circumstantial evidence. So I'll try to build up the chain of circumstances, pointing out to all the links, and lordship will find out whether those links are complete and the chain is established. I have made a note. I have made a note for your lordship's perusal. So lordship need not write. Whatever I'll say, I have jotted it down in my note. Lordship need not write it. I'll submit it. So the first circumstance I would like to place is that the victim was alone in the house. I'll go one by one so that it makes out a complete chain and it leads to the guilt of the accused. The first circumstance is that the victim was alone in the house. This was stated by PW4, and I'll show those evidences which establishes the link. PW4, lordship will see who had stated what in relation to that link. PW4, the father of the victim, he stated in his examination in chief that on lordship will get it in page 19. On 14:03 in the morning hour, the second paragraph, I along with others went to Zoom cultivation at a walking distance of so and so minutes. Thereafter, my wife room and daughter Jolly room went to the house of Kanata room for husking paddy. My other two daughters, Vishnupriya, Deba room went to their school. My daughter Kini room was alone in the house. So it was known he went there, daughters went there, wife went there, and then the victim was alone in the house. This was also stated by PW8, the sister of the victim, which lordship will get it at page 29. The sister of the victim, she also has stated in her examination in chief that I with my mother went to the house of Kananta, keeping my sister in Kimru Riyang alone in the house. We actually should not spell out the name of the victim in order to keep the secrecy. So here the victim was alone in the house. So the first circumstance is that the victim was alone. Second, lordship will go that the appellant, he
You're challenging the order of 8/1/2013.
Yes, your lordship.
There's something about impleading. There's something about impleading. What was
Yes,
it?
we have filed an IA for implement of new applicants, your lordship, and new trustee members in the said trust, because some of the members are expired and they passed a resolution for appointment of new trustee, your lordship. So for some reason, IA has not been.
Lordship, this is a
Just a moment,
1988
just a
suit.
moment, just a moment.
Yes, my lord.
You are the petitioner here.
Yes, lordship.
You have filed an application for impleading someone.
Yes.
Whom do you want to
Impleading,
implead?
4 applicants, your lordship.
You want to implead more applicants?
4 applicants, and struck off the name of some of the applicants, they've expired.
That will not be permissible. On what basis are you making that clear?
Because the trust, they have taken signed a new appointment of trust deed. Therein they have appointed some new members. Also, some of the earlier members have expired, your lordship.
Show me your application. Who is the plaintiff? Arun Chandra Rajvanshi.
With the original plaintiff.
You are representing them also. You are representing them.
Actually, now, lordship, the change, he has filed the IA against him. Or
No. First of all, who is the petitioner here? Who is representing the petitioners here?
the original petitioner, Arun Chandra Rajvanshi and others.
Huh.
And others.
Who is representing? You are representing them.
Yes, we are representing them, sir.
This application will not entertain here. You'll have to go before the trial court will permit you to make that application there in the suit. In this this order, we are concerned with the maintainability of the counterclaim.
Counterclaim, Lordship.
Some of the
This is an original adjudication. We'll not do it here. In a revision, we are not entertaining those applications for impleading.
Lordship, if I may
It
submit,
is something to do with the suit.
no, the most relevant part here is their original suit was for reconstituting the board of trustees of the trust deed in reference here. Now, my lord, from my learned friend's submission, it appears they have reconstituted the trust when the entire matter pertaining to the reconstitution of the trust is yet to be decided. Title suit 76 of 88, that is not yet decided. They are not granted the liberty to reconstitute the trust deed. Against an order allowing the counterclaim of the respondent numbers 1, 2, and 3, they have filed this revision petition. Now, during the pendency, when the matter is yet to be decided, how can they reconstitute the trust deed, my lord? Anyway, that is not the issue here, my lord, but if,
This will be not in consonance with the prayer here.
yes, lordship,
This is, we are not allowing this.
we cannot
Come to the main
reconstitute
application.
the board of
The-
trustees.
There's a counterclaim. Court has held that the counterclaim is within limitation and therefore maintainable.
Yes, lordship. The issue here, my lord, the respondent numbers 1, 2, and 3, they filed a separate suit while this original title suit was pending, because We
No,
have,
let him start. He is a petitioner.
yes, I'm
I'll
sorry.
come to you when hear you.
Well, also in that case, kindly a date may be fixed.
No, we are not adjourning these matters.
And
These are
it's
top
not
of the
been
list
tagged
matters. We are not adjourning.
If on tomorrow also can be.
No. Suppose it off today. The assistants are not assisted. Adjourning matters. Top of the list matters are not to be adjourned.
No, it's not
They're not
changed,
adjourning.
it has not been tagged, that's why.
No. Heard Mr.
It does.
K. Das, counsel for the petitioner. And the
Sharma
K.
Lordship,
Sharma.
for
counsel
respondent
the-
numbers 1, 2, and 3.
Respondent numbers 1, 2, and 3. Yes, sir. The also the learned counsel for the petitioner has placed for an adjournment. This being a matter of 2013, therefore adjournment is refused. Next paragraph. This division under Article 227 of the Constitution of India directed against order dated 8/1/2013 passed by the learned Civil Judge number 2, Kamrup Metro, Guwahati, in TS number 76 of 1988. By the said order, the learned trial court had taken up for adjudication the preliminary issue raised by the petitioner as to whether the counterclaim of defendant numbers 16, 17, and 18 was maintainable or not. That preliminary issue was decided in the affirmative by holding that the counterclaim of the defendant numbers 17 and 18 being not barred by res judicata was maintainable. Next paragraph. From the materials available on record, it appears that the plaintiff in the suit had paid for a declaration that suit was filed under section 92 CPC for appointment of new trustees by removing the defendants as trustees and for accounts of trust. In the said suit, the plaintiffs had prayed for number 1, the removal of the defendants from the office of trustees. Number 2, Roman 1, Roman 2, appointing new trustees and vesting, VESTING, within brackets SIC. The trust property in them, 3, directing accounts to be taken from the defendants of the income of the trust property and payment of the balance to the new trustee. Any other relief or is the plaintiff may be entitled to for 5 cost of the suit. Property is a next paragraph, is a land measuring it appears that it appears from the record that the written statement was filed by defendant numbers 1 and 2 and defendant numbers 17 and 18 had filed the written statement as well as the counterclaim against the counterclaim. Written statement was filed by the plaintiffs. Next paragraph. In the counterclaim, defendant numbers 16, 17, and 18 had paid for dismissal compensatory cost and for a decree of cancelling the deed of trust dated 5/9/1970 and for declaration of the right, title, and interest of the defendant for 16, 17, and 18 the land as well as for permanent. The written statement filed against the counterclaim, amongst others, he was taken the effect that title suit number 82 of 2006 filed by the defendant numbers 17 and 18 was dismissed by the Court of Munsif number 2, Kamrup Metro Guwahati, under Order 9 Rule 8 EC, and therefore was contended that the defendant numbers 16, 17, and 18 were precluded from bringing a fresh suit in respect of the same cause of action. And that the counterclaim has been filed by suppressing fact of dismissal of the previous suit. In the said proceedings, by filing petition number 257 of 2012, dated 10/8/2012, clear was made for framing a preliminary issue as to whether the counterclaim of the defendants was maintainable in the eye of law. as per the contents of the petition, no objection was filed to the said application by the defendant numbers 16, 17, and 8. By the impugn order done at trial court, had examined the certified copy of the paint of title suit number 319/2004 within bracket old, corresponding to PS number 82/2006 within bracket new. A written statement filed in the said suit, as well as the order dated 10/5/2010 passed, and expressed an opinion that the subject matter in TS 82 of 2007 and counterclaim of defendant numbers 16, 17, and 18, same and the relief sought for is also substantial. That the case number 82/2006 was dismissed by the learned trial court, the order dated 10/5/2010 for evidence not being adduced in support of the plaintiff's side. Accordingly, order was passed in view of the provisions of Order 9 rule. We mentioned that as per the contents of the impugn order, defendant numbers the learned trial court note of the provisions of section 11 CPC made the following observation. Yes, insofar as the order is concerned, how do you, what is your submission
Lordship.
against the order under challenge? What is your submission?
My submission, Lordship, notwithstanding, I had filed a suit, but a separate suit on where we subsequently implemented as parties. Therefore, we filed our written statement and the counterclaim, which was rightly allowed by the trial court.
The order of the trial court is not sustainable. Second suit is precluded for the same relief.
But whether in a pending matter, Lordship, the counterclaim will be precluded.
Yes, it will be, because it will be a separate suit. The order of the trial court was probably wrong. Come to order 9. Order 9, rule 9, decree passed against plaintiff defaults bars the first suit. That is not permitted. You're wanting cancellation, but that there is a decree operating.
But my lord, if the, even if the, as per order rule 9, order 9, if the counterclaim goes, but Lordship, the part of the written statement will still,
Written statement will remain.
because we Lordship have challenged, my lord, the, our challenge is the trust, and the primary challenge, Lordship, is that it's not a public trust, rather a private trust, and therefore the provision under which it has been filed, it is not maintainable. So we have already raised those issues. Even if the counterclaim goes, Lordship feels that, or if it is seen that the counterclaim goes, my lord, let the written statement be there and let the
No,
matter
that will
go.
remain, that will not go. That will not
Proceed.
go.
Since 1988, my lord, our land, our ancestral land has been held up by these so-called trustees. And then Lordship, kindly see, they file a suit for reconstituting the board of trustees. Now they file a petition saying that they have already.
That we are not accepting. That application.
Yes, Lord.
Trial court.
So my lord, the court should proceed now, because it's, my lord, this is third generation who come to the courts.
On from the above, it appears then a trial court proceeded in the matter by considering the provisions of section 11 CPC and formed an opinion that the previous suit, i.e., it is the TS 86 or 82 of 2006, was not finally heard and decided by the learned Munsif. However, the learned trial court failed to take into consideration provisions of Order 9 rule 9 of the CPC is quoted below. Order 9 rule. Next paragraph. It is further observed from the impute order, the categorical finding of the learned trial court was that the subject matter in previous suit as well as the present suit were same and the relief sought for counterclaim. Counterclaim were filed between the same parties. Next paragraph. Relevant to state that as per the provisions of clause 2 of rule 6A of order 8 CPC provides that the counterclaim shall have the same effect as the cross suit, so as to enable the court to pronounce a final judgment in the same suit, both on the original claim and in the counterclaim. Therefore, although the nomenclature of the claim made by a defendant in a suit is referred to as a counterclaim, has the same effect of being a cross. And that, as per the provisions of clause 4 of rule 4 of A of or 8 CPC is provided that the counterclaim shall be treated as a plaint and governed by the rules applicable to the plaint. in order to arrive at the decision, the learned trial court had placed reliance. Gujarat Electricity Board is SAURASHTRA Chemicals. AJK 2004 2J at citation level AR 2004 Gujarat 83. That's what they said. As I said, judgment. Of the respondent in the said case was decreed only that the respondent as plaintiff was entitled to recover amount of he mentioned therein from the defendant's interest. In appeal preferred against the said decree, contention was raised. There was a previously instituted, and therefore the was contended that present suit was barred. Few of the provisions of Order 2 as well as Order 9 Rule 9 tries to mention that the second suit was held by the Gujarat High Court to be not maintainable. In view of the provision, the 2 rule, the 9 rule 9. Accordingly, the decree passed in this was set aside and quashed. Height of the that finding recorded in the case of that is we are unable to appreciate the finding of the learned trial court that suit the dismissal of suit under Order 9 Rule 8 CPC not operate as a adjudicator being subsequent. Therefore, comma is basis of which in order dated 8/1/2013 found to be without any basis and in view of the provisions of Order 9, Rule 9, in order. 1,2000. As per the learned. Not sustainable. So they said there is stuff matter relating to the number 57 of 12, date 10/8/2012. So there's number 2 for fresh adjudicating by taking into consideration the in the order will be construed. Moreover, while adjudicating the put and take into consideration technically the witness statement up to the extent leaving this stage. Current counsel for the applicant IA an interrogatory application in IA Civil 3615 of 20 filed in connection with the revision petition for the application is not on board. As it may. In light of the prayer made in the suit, after hearing the court finds application for this application, copy of which has been produced by the learned counsel for the app, is projected that some of the applicants herein claim have entered into the concerned trust as trustees. Therefore, the prayer is to complete the applicants as petitioner number 3, 4, and 5 by striking out the names number 2 and 3. In light of the prayer made in this suit, comma. The to consider opening that if the interlocutory applications and is allowed, comma, it would run and operate contrary to the prayer made in the paint. Therefore, comma, court is inclined to that application is that application, comma, copy of which was used by the learned counsel, comma, that application stands closed, but it will be again near the prayer before the trial court advised. Accordingly, the registry shall treat the head IS Civil 3615 of the
Place.
copy of petition produced. Petition as IS Civil. Both sides are represented by the learned counsel. L here for the court of learned judge Guwahati on 9/10/2020 by producing a copy of this order of the instructions.
Place.
Yes.
On behalf of PN Goswami. No,
I'm not hearing you. Please turn your speaker. Open. Speak loudly then.
PN Goswami sir will not longer appear in this matter.
Please speak loudly. I'm not
PN
hearing you.
Goswami sir will no longer appear in this matter.
We don't take cognizance of that. Your name?
W. Ahmed.
W.
Ahmed.
Ahmed. So W. Ahmed, counsel for the petitioner submits that they are no longer, he's no longer appearing in the matter. Just cognizance of the said submission cannot be taken by the court, as it was the duty of the learned counsel to give a notice in writing to the petitioners of their intention to recuse from the case. Just of the same having not been done, or the court would.
My lord. Lordship, other two counsels are appearing, will be appearing, Jay Singh and KK Henry.
I don't know those things. And whatever is not on record, I am not taking cognizance of anything. According to the court, still, still. The present set of counsels continue to remain on record. Even if they choose not to address the court. Next paragraph. This matter being a revision of the matter to of the year 2013. Court is inclined to proceed with the matter without the assistance of the learned counsel for the applicant, for the petitioners. Next paragraph. By the impugned order dated 5/1/2013, passed by the civil judge number 2, Kamru Metro Guwahati, in Misje case number 2 of 2011, in the proceedings of TS 21 of 2009, the said learned court took up for adjudication an application filed under orders 47, rule 1 and 2, rule 1, read with section 151 CPC for review of the judgment and order dated 6/12/2010, passed by the said learned court in TS number 21 of 2009, thereby dismissing the suit of the petitioner plaintiff. Full stop. Next para. It appears that it appears from the LCR that the player in the suit is for a decree of declaration that there exists no arbitral agreement between the plaintiffs and the defendant number 1. Number 2, a decree for declaration that there be no arbitral agreement between the plaintiffs and the defendant number 1. The defendant number 2 has no power and jurisdiction to act as an arbitrator. Number 3, a decree of permanent injunction restraining the defendant number 2 in passing any order against the plaintiffs in the so-called arbitral proceedings commenced without jurisdiction and presently said to be pending before him. Number 4, any other relief. Number 5, cost of the suit. Next one. I indicated herein before, The suit was dismissed. No, no. It appears from the impugned order, from the contents of the impugned order, that the learned civil judge number 2, Kamrup Metro Guwahati, in TS number 281 of 2007, had passed an order appointing an arbitrator. And accordingly, the court was of the considered opinion that the said suit was an appeal in disguise. And therefore, it was held that the court cannot sit on appeal over the decision rendered in TS number 281 of 2007. Full stop. Stop. The set factual position could not be dispelled by any material which is contained in the revision in this connected revision petition. In this revision petition. Full stop. If an arbitrator has been appointed, or the court does not find any error on the in the impugned order, for dismissal of TS 21 of 2009. Full stop. Resultantly, comma, the learned trial court is to have committed no apparent error in refusing to entertain a review application. Full stop. Next paragraph. In the review application being this case 2 of 2011. Is it next paragraph? Come on, there's been the ground number A relates to acceptance of service of notice by taking recourse to section 27 of the General Clauses Act, which is not at all relevant to seal the impugned order in review. The impugned order dismissing this suit, which is subject matter of review. in ground number B, it has been stated that in the proceedings of TS 281 of 2007, the learned civil judge number 2 had not passed any order for appointment of arbitrator. And in this regard, reliance was placed on the copy of order dated 9/8/2010, by which, according to the petitioners, the plaintiffs were permitted to withdraw PS number 281 of 2007 from the court of learned civil judge number 1. Copy of the said order dated 9/8/2010 has not been annexed to this application. Therefore, the LCR was perused. Full stop. Full stop. Stop. In the record of in the LCR, the copy of order dated 9/8/2010 is found appended as Annexure B to the review petition, being Miss Case number 2 of 2011. And as per the and the said order reads as follows. Let's see, last. Pink flag. The petitioner's hearing appear to be the plaintiffs in the said TS number 281 of 2007. The petitioner number one, go here. Petitioner number one. Just it cannot be said if there are any other plaintiffs in the said case. First, therefore, on examination of the factual matrix, it appears that in the observations made in the order dated 6/12/2010 asked in ES number 21 of 2009 by the learned Civil Judge number 2, Kabra Metro, Guwahati. The following effect dash inverted comma, it may be mentioned that in TS number 281/07, comma, the court had appointed an arbitrator to stop the defendant number 2, the Pankar Ghosh, DIPANKAR GHOSE, was appointed the arbitrator. Full stop. Never comma closed. Is factually incorrect and inconsistent to the certified copy of a photocopy of the certified copy of order dated 9/8/2010, referred to herein before. Stop. Therefore, it appears that the petitioner has been able to successfully show that the impugn order dated the order dated the order dated 8 6/12/2010 passed by the learned Civil Judge number 2, Kabra Metro, Guwahati in TS 21 of 2009. Was vitiated by error apparent on the face of record. However, no conclusive finding is returned as the certified copy of the order dated 9/8/2010 in TS 281 of 2007 is not available in the LCR. Next paragraph. Resultantly, the court is of the considered opinion that as the order dated 6/12/2010 was erroneous on facts, the review would otherwise be maintainable against the said order, as no appeal has been filed, which is the condition precedent of filing a review under Order 47/1 CPC. Accordingly, the Court is inclined to set aside and interfere with the interim order dated 5/1/2013 passed by the learned Civil Judge number 2, Kanpur Metro, Guwahati, in Ms. J case number 2 of 2011, by which the review application was dismissed. Resultantly, as a consequence thereof, the proceedings of Ms. case number 2 of 2011 is restored to the file of learned Civil Judge number 2, Kanpur Metro, Guwahati, for a fresh decision in accordance with law. We are examining the records of TS number 281 of 2007, which is referred to in the order dated 6/12/2010, passed in TS 21 of 2009. Next paragraph. The petitioners are directed to appear before the learned trial court on 6/10/2023 by producing a certified copy of the order and await further instructions from the said learned court. Next paragraph. Revision stands allowed that the LCR be sent back expeditiously. Yes, number 4. I did not in fact notice that this was a bail application pending. I would have
Yes, sir. This is
raised
for
you earlier
cancellation. This is for cancellation.
for cancellation.
May I please, Lordship?
It's come for the first time? No.
Lordship, this is the application for cancellation of bail, Lordship. This order was passed by your Lordship. The
Just a moment. Just a
Order
moment.
Perhaps it has
is-
come up for the first time, the notices.
Just
will
what I'm
go.
asking. Come for the first time. I thought you
Yes,
should notice.
notices will go.
Mr.
R. Islam.
R. Islam, counsel for the applicant, and Mr. S. Jahan Ranwati for the state. Jahan Ranwati who accepts notice on behalf of the state. Next paragraph. Issue notice on the respondent numbers 1 and 2. Returnable on what time?
6/11.
2022.
Excellent. Returnable, Lordship.
Applicant shall take steps within 7/9/2023 for issuance of notice on the said respondents by registered post with AD. In addition, steps shall also be taken by usual process to be routed to the to be routed by the registry and sent to the jurisdiction magistrate for service. Next, 6/10/2023 awaiting service of notice on the respondent numbers 1 and 2.
May I pay for a short date, my lord? May I pay for short date, my lord? Because they are threatening
I'll give
us.
you tomorrow.
No, Lord.
Then by when you will serve? Can you give us a assurance? By when you will serve? In criminal, we can't give dasti.
No, Lord.
Not
That is
provided.
possible.
So what can we do?
So,
We can't give you the authority to serve. We can't expect service by the police prior to 2 weeks. We don't even expect our registry to process the my order within 3 days, because it takes 3 days time for the order of the court to reach the section. We have our limitations. Correct. One day you move along with your advocate's clerk in these sections, and then you'll know what is the time limit, what is happening when.
Lordship.
obliged.
5 for orders.
Now, 5, Mr. Mishra is appearing. He came in the morning, but he was not feeling well. He fell unwell.
Yes, sir.
So Lordship may take it up some other day. he has prayed for 12th of October.
12th October.
Yes,
It's just close to that, no,
that will of course be a motion week.
the motion week. We'll make it 10th, in fact. 10th,
10th,
second half.
10th, he had some other matters fixed in
10th,
both
second
one.
half.
And then
Uh-huh.
the week before, October, he'll give a try on 5th then. Huh?
5th.
11th. 11th then.
11th. No, because
11th
you
is
see,
Wednesday.
Mr. Mishra, from his demeanor in the court, he appears he'll take some time because that day we can't afford that,
Yes.
that amount of time. So
That
that's
is why
why.
I'm saying 5th of October,
Make it 5th of October. We'll give a try.
3rd of October. 3rd of October,
First week, any day you want.
3rd will do. We'll give a try.
Both sides are duly represented.
3rd or 5th, any day, Lordship's convenience. If it's not possible, we make a mention of it.
It appears that the hearing of the due to positive time, the matter could not be